Welcome to the Estates Made Simple podcast with Jenna Carvalho and Gordon VanderLeek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
We get to do another episode of Estates Made Simple. Welcome to our listeners and our viewers on YouTube. And we're delighted you've tuned in for another episode. And today we're going to be talking about Henson Trusts. Now, that's an interesting name, and we could talk about how that came about. But before we jump in, welcome, Jenna. Glad we have an opportunity to record another episode for our listeners on this important topic about, in particular, relating to disabled beneficiaries and how do we manage the trusts that may have been created and arising from the estate, if you will. It's stuff that's laid out in the will.
Thank you, Gord. I'm looking forward to this because I know that Henson Trusts and disability planning is really an expertise that you and your firm hold. So I look forward to asking you some tough questions, putting you on the hot. So why don't we start with your comment of how did the Henson Trust get its name?
Yeah, so it actually came out of a case in Ontario that was leading in this area. And the problem there, that their provincial program in place had rules about what people could own and still be eligible for those government support programs. And what had happened is the family had set up a family trust. And then this person who was eligible for government supports in Ontario was removed from entitlement, so kicked off the program, right? So the family appealed it and it went through the court system in Ontario. And the court ultimately confirmed to say, if you are a beneficiary of the trust, then that is not an asset that you own. And therefore, the fact that you're a beneficiary does not lead to disentitlement, or it doesn't deny eligibility for those government programs, which is a big deal, right? Because typically the parents or other family members would want to leave money for the benefit of this child, because typically the disability may mean they don't have the ability to support themselves through employment and their own savings and accumulation of wealth. So the provision through a trust structure is typical if you have a child with a long-term disability. So as a result, we started calling these types of trusts Henson Trusts, because that was the name of the case. The family was the Henson family that did battle through the courts with the Ontario government. And then it emerged with very specific rules regarding what qualifies as this type of trust, what works to maintain eligibility for government support programs for a disabled person. Now, the interesting scenario in Alberta, and this is where we're getting specific to the Alberta situation, is that it took until 2018 for these types of trusts to be recognized in Alberta. And the government at the time changed the AISH rules, the act and the regulation, to be able to say that trusts are now an exempt asset. The interesting thing when we look at the history of where did this all come from is that we actually have a more liberal and broader definition of this exemption under the AISH regulation, AISH being the Assured Income for the Severely Handicapped. That's the acronym for that, the name of that program, which is a provincial program supporting Albertans who can't support themselves because of their long-term disability, and has to be a severe disability. That you could argue a better way to call it is actually an AISH trust, because the rules are different. But the reality is, it's really complicated to say, what about a trust with absolute discretion for a disabled beneficiary for the lifetime of that person, which is friendly as far as eligibility for government support programs? That's a mouthful. So instead we just say, oh, Henson Trust. And then everybody knows that's what you're talking about, even though that's an Ontario solution, if you will, that came out of Ontario. And you could argue in Alberta, a better thing to call it would be an AISH trust. In other words, a trust that will ensure ongoing eligibility for those benefits under the Alberta situation. But when we say Henson Trust, I think it's been out there so much that people know what you mean when you say that. So I think we'll continue to refer to it as such. And the interesting thing in terms of the AISH regulations, if you look at the definition, it just has two words. When it says, what are exempt assets? And that would be, it just says a trust. It doesn't say a trust with absolute discretion, or it doesn't say a trust that isn't more than $250,000. There's no limit on the trust. There's no condition. It just has to be a trust. So it can qualify as an inter vivos trust, a trust set up in one's lifetime, or a testamentary trust, one that arises when somebody passes away. And so if now we have a beneficiary, somebody who's a recipient of the AISH benefits, and they are the beneficiary of the trust, that does not kick them off of trust. But it has to be a properly constituted trust, of course. We have to ensure it's set up appropriate to all the normal legal requirements for setting up a trust. But once properly constituted, if it's a proper trust, then it would fit the definition and therefore be exempt. So the fact that somebody receives an inheritance, and that's usually the scenario, or they come into some money and put it into a trust, then in that circumstance, they can continue to be eligible for AISH. The rules came into effect, passed in the summer of 2018, but came into effect April 1st, being the first day of the next fiscal period for the government. I think that was why the date was chosen, of 2018. So it's been around for a while, for these 6 years, and it was a huge change. We saw many people who were previously kicked off of AISH because they were the beneficiary of a trust now could reapply and gain those benefits back, which can be a real lifeline in terms of paying day-to-day expenses on that.
And I think you've touched on my next question, but if our listeners here are acting as a trustee for an AISH trust or a Henson Trust, what is the primary consideration they really need to think about when they're acting?
Properly managing the money and doing all those things. We've talked about that in other episodes, so let's assume that people are understanding their normal legal obligations. I think particularly relating to these types of trusts, what you have to be super careful about is how do you push money out of the trust? And what I would say is there's an inherent kind of tug of war or conflict between the tax efficiency and what's best for the AISH rules. From a tax efficiency perspective, you could argue the best thing to do would be push the income generated in the trust into the hands of the beneficiary, because if they're on AISH, that they're low income. It's not that much money, right, that they get on an annual basis. So the accountants or the tax advisors would say it's better to have it in the hands of the beneficiary than it would be in the trust, because the trust may have a higher rate of tax than the beneficiary who has low income or no income. But the problem is that AISH will take a look at the amount of income. So while it's true that now these Henson Trusts work in Alberta, and they did since 2018, the government both gave that benefit and then took a little bit away by saying, but we're going to monitor the income that comes out of the trust into the hands of the AISH recipient, or being the beneficiary. And so they will monitor the income. And so you just have to be super careful, because income in the hands of the beneficiary could result in clawbacks. So there's an exempt portion, and there's a formula in place. Without getting too much into the weeds, the formula at present, if you're listening to this beyond the spring of 2024, check on what the rules are, because these can change over time, is that it's currently $300 plus 25% of the balance is exempt, and the rest of it is non-exempt and might result in clawbacks to the monthly AISH entitlement. So you have to be super careful about how you push the income out or deem it to be pushed out, for example, with a preferred beneficiary designation. Even if the person didn't receive it, you might create an AISH problem resulting in clawbacks for the AISH program. So from that perspective, yeah, be mindful of the decisions you're making and balancing the tax efficiency with what's best for the AISH rule. So it does require some professional advice, in my view, and some calculation of what's in the best interest. It might very well mean that we should keep the income generated from investments in the trust and pay the higher rate of tax, because we don't want to create an AISH problem, or at least develop a strategy about how much to push out and when to push it out. And professional advice is required to optimize that plan with whatever the rules are at the time. That's the current rule, but of course that in 2018, it was a different number. For example, it was $200 plus 25%, and then they increased it a few years later. So the number hopefully will be amended from time to time, but you got to be careful with regard to that for sure.
And so we chatted a lot about an income test, but in terms of also a capital test, you mentioned that the balance of the trust is exempt from AISH rules or the calculation of AISH benefits. And then there's other capital property that can be exempt. So a vehicle, an RDSP, primary residence, and as you told me earlier today, prepaid funeral plans. And so as the trustee, when you're managing a trust, can the trustee disperse funds to the beneficiary to purchase these items? Or is it better, or does it make a difference if the trustee purchases it on their behalf?
I would say the latter is probably the safer, and typically what we see is the right answer. You got to look at each case to see. But for a couple of reasons. One is if you're pushing money into the hands of the beneficiary, then where is that reported? Now, it might be a capital distribution, so maybe that's okay because you're just distributing capital. But as you say, there is an asset test under AISH. There is the rule that you can only have an AISH recipient can only own $100,000 of non-exempt assets, whether it's cash in the bank, a TFSA, an RSP, other investments that are not part of the list of exempted items, right? That of which you mentioned. So we can't push so much capital out to the AISH recipient, or they're going to be offside the asset test because it's more than 100,000. But so arguably you could do that without clawback. But if you're trying to characterize it as income, then we might have an AISH problem. Some of that may result in a loss of monthly benefits. So you got to be careful how you push it out. So I think what normally happens would be the trust would purchase it, right? So if a home is needed, the trustee could own that using trust property to purchase the house. The house being part of the trust would be exempt. Now, if the person owned it, it would be exempt as well. But it brings up that whole issue of if the AISH recipient owns it, are we worried about, or is there an issue in relation to controlling that? Right. And now it's part of that person's estate, right? When that person passes away, where does that property go? Which may be different than the terms of the trust. So the other point I want to make as part of this podcast is you have to carefully review and determine who are the remainderment beneficiaries, because the trust typically should specify when the AISH recipient passes away, the disabled child, when they pass away, where does the balance of the trust fund go? And there's probably terms and conditions for that. So if you deal with the property inconsistent potentially with their position, you might have the authority, or if you don't, maybe it creates a legal issue. So definitely something you want to get some legal advice on and be mindful of where the money is going to go and where the property is going to go. So typically the safest bet would be to keep it all within the trust, because that eliminates then the argument that you diverted the money to somebody else and it affected the rights of the remainderment beneficiary on that. But that is specific to the way in which the trust was drafted and specific to each case. So it's hard to make a general rule other than what I've said. It's to be cautious, and definitely you want to get some advice to make sure as the trustee of the trust, you're not running afoul of your legal obligations, that or if you are doing a capital distribution, you have the necessary authority to be able to do.
Right. And I think what also could come into play is asking the question if the beneficiary has their own will, because maybe they don't have an estate plan for themselves. And so distributing assets into their hands, as you mentioned, may not be ideal. Where does it go when they pass away? And I think all this discussion really highlights the importance of seeking professional help when you are acting as a trustee for any trust, but particularly Henson Trusts. And so do you have any final tips for our trustees that are listening today, Gord?
The other thing to be mindful of with regard to these types of trusts is there is the prospect. It's not universal on all of these types of trusts, but there's the prospect of having the trust qualify or set up as a qualified disability trust. That involves an election with CRA and a check the box exercise on the return to say we want this to be a qualified disability trust. The main criteria for that is that the beneficiary, this AISH recipient we're talking about in this podcast episode, would be qualified for the disability tax credit. Assuming that's the case, then there may be the ability to get a lower rate of tax. All of this is not intended at the end of this podcast episode to get into a detailed discussion of the qualified disability trust, because that's maybe a whole other podcast episode. But it highlights the importance and the need for good accounting advice. So I think in this situation, the advice would be get to the accountant early. If you see this kind of complicated trust, recognize that there's going to be a whole bunch of rules in the Income Tax Act and the policies of CRA that are going to impact your decision as the trustee of the trust. Whereas it's not something that you put off or avoid, because you may miss an opportunity to make the appropriate deduction. So I think you want to get the accounting professional in early. On a prior episode, when we had an accountant on, I think that was part of the messaging there as well, right? Even in the context of the estate, is get to the accountant early, because you don't know what you don't know. And you want to know what your deadlines are, or when you have to make certain decisions. Because the problem with the qualified disability trust, as I know it, is there's really no ability, if you miss the deadline, to go back and fix it if it's lost. So it just highlights, because of that unique rule, which may not be self-evident, that may not be the most important thing you're thinking about right at the beginning of the estate, which is a very busy time dealing with getting the estate set up. I'll deal with the accountant down the road, but then a lot of those elections have to be made by December 31st, for example. So if somebody passes away in October and you don't get around until February or March to talking to the accountant, you may have missed that deadline, right? Which then you're accountable for that decision. While it's good advice to get the accountant on early, and that's a message we've given on this podcast before, I would doubly emphasize that in the context of a trust for a disabled beneficiary, that you need that advice. You want to know what those deadlines are, get the appropriate professional advice, and then just make sure we don't miss those deadlines, right? So get the professionals on early. And there's unique legal issues, and you want the accountant to be talking to the lawyer, and to what we started with talking about, that there can be problems on how you distribute the money. Recognize you might be getting input which is slightly different from your professional, so you have to manage that process, but getting them on board and everybody communicating as a team would help to come up with a plan that will ultimately be good protection for you as the trustee of the trust. And ultimately, then we have a smooth running trust for the benefit of this person you're managing the money for, right? The disabled beneficiary who might have these AISH benefits.
And before we close, I'm going to brag about you, Gord, because I know you're not going to brag about yourself on here. But for our listeners, if you are dealing with a disability trust or a disabled beneficiary, Gord is an excellent point of contact. He and his firm advocate for disabled people. They're able to provide services for getting additional government benefits that maybe the beneficiary wasn't aware of, and just providing that support and guidance along those non-legal matters as well. So I highly encourage you to contact Gord and his team, and they'll take really good care of you.
Thank you for your kind words. That's heartfelt on my part to hear that. But I guess looking at the practice and how it's evolved over the years and the more work we're doing in this area, it's a bit of a passion project of ours. Obviously, we have children with long-term disabilities, so we're invested in this area because it affects the VanderLeek family, and we'd love to share our knowledge with other people. But what you really see, maybe that's a bit of the theme of this episode, is the interconnectedness. Right. And we go, a decision in one area has an implication in another area. And then what about the guardianship and trusteeship order? And what about the AISH benefits and advocating? What about other support programs? And a decision in one area can be linked to or affected by what's in place in other areas. So we find that benefit of having that comprehensive review, right, and a knowledge base to be able to address all those areas and provide some integrated advice, as opposed to we're just looking at the trust. You also have to understand the AISH rules, right, to know how to manage the trust, because that's relevant for the beneficiary. That's acting in the best interest of the beneficiary in that regard. And obviously for families that have children with long-term disabilities, I guess you could take from this podcast also that planning is required ahead of time to get that all set up. So whoever is managing that trust when you pass away, which is part of that whole estate process, that they have the right tools they need and it's optimized as best you can. So it really does require advanced planning to do that. But yeah, I do appreciate your kind words. We love working in this area, love helping other families, and we do hope to be doing it for many years to come.
Thank you everyone for listening. We appreciate your support. Please feel free to subscribe or wherever you listen to podcasts, and we look forward to chatting with you next time.